page 6. And finally, page 7. Are there matters arising from the minutes? Oh, sorry, I skipped a step. We'll move to confirmation of the minutes if there are no corrections. So moved by Senator Morrison, seconded. Seconded by Member Golden. All right, we'll move to matters arising from the minutes. I note that in the minutes, Member Golden had asked whether the consultant was contracted by the government to look at just the cost of establishing the information commission. And at that time, Ms. Murray did not have the information, but since then, we've received an assessment. We've received a report from the consultant that was contracted. So, Ms. Murray, do you want to just give a quick update?
Thank you, Chair. We had actually provided information that was requested, i.e., that is what the possible cost of the establishment of the organization would be. And we had also, which at the time, and what we would have shared was 1.7 billion for at least the first year. We can report that the consultant indicated that the cost would go up incrementally. So the second year would be about 1.8, and I think the third year as well, another 1.8 and change. I would have also shared, members would recall that there was a recommendation that the registration fee be about $12,000 and that focus be placed on, in the first instance, larger companies and medium companies as opposed to micro and small. So the report, copies of which we have available and is being shared, would outline the basis on which the consultant arrived at the cost for the, well, for certainly the first 3 years of the organization. Just to say that this is a draft final report. The ministry will, of course, consider the report in the context of and in discussion with the Ministry of Finance and the Public Service before the determination is made. But since the committee had requested that we share the report is shared.
All right. Thank you, Ms. Murray. I just noticed that the date on it is December 28, 2018. Is that an error? Should it be 2019? No, it's 2018? Okay.
Chair, the other matter arising from the minutes was we were asked to look at the cost of business registration and company registration at the Company's Office of Jamaica. We conducted some research, and based on the information found on the website of the COJ, what we have seen is that with respect to registration of business names, it varies depending on the type of registration, i.e. whether you're a sole trader, a partnership between 2 and 5 partners, a partnership between 6 and 20 partners, or a registration of a trade name. The registration fee, however, starts at $2,500. 2,500 for sole traders, partnerships between 2 and 5, partnerships of 6 to 20 partners, 5,000, and registration of trade names, 3,000. There are some additional costs. So, for example, registration of the branch or branches, that's an additional cost of $1,000. Notification of change of particulars has a separate fee as well, and other miscellaneous fees. With respect to registration of companies, while $24,500 is charged for filing the articles of incorporation, but members will recall that there are a number of other additional documents that are required to be filed upon registration, including the appointment of the company secretary, appointment of directors, and notice of appointment of the company address. So while the articles of incorporation, the filing of that is $24,500, the additional filings of separate documents on first registration brings it to about $34,500 in total. And then, of course, there are annual filings which attract costs. For example, the annual return varies from 2,000. Well, there's one for 2,000, one for 5, and one for 7,000. I think depending on the type of company, I'm not sure. And then, of course, any change in corporate secretary, change in the company address, and or change in directors, the filing of those documents attract a fee. So first registration with the articles and all the attendant documents that are required for establishment or registration of the company, rather, that cost is $34,500. Well, thereafter, there would be, companies are required to file an annual return, and that cost can be either 2,000, 5,000, or 7,000. But if there are any changes to directors, for example, or company secretary, or change of company address, then that would require the companies to file those changes, and then that would attract a cost. So
they have an next step though, that's only when you're incorporating a company, a limited liability company, because if you're doing a trading as business, then you don't have those attendant costs, and trading as I think is $3,000, and you don't have the yearly fees that you have to pay.
Right. And remember, I would have said that when I spoke about the registration of business names, the registration of the sole trader being 2005, registration of partnerships. So I was speaking just now specifically to companies. So for the registration of businesses, yes, sole trader 2,500, partnerships 2,005 or 5,000, depending on the number of partners, and the registration of a trade name, which would be 3,000. So that's just a one-off fee.
All right, thank you for that information, Ms. Murray. I think there's one other item as matter arising from the minutes. On page 14, MSET was asked to look at why Malta page 14 of the report, the first paragraph, the last sentence that says, since we were not provided with a response from MSET as to the reason the provision was repealed in the UK and Maltese legislation, the member who raised the concern suggested that clause 19 be deleted or amended, and MSET was to bring some kind of an explanation.
Good afternoon, Chair and members. We did some research around the issue, and we weren't able to find a rationale provided by Malta in relation to the deletion of a similar provision in its legislation. And in relation to the UK, what we found in looking at how the Data Protection Authority there, in doing a review of the application of the 1998 legislation, what was indicated was that the Commissioner had no reason to issue any order under this particular provision in the UK legislation. In fact, what it said was that no order has ever been issued in which any types of processing, similar processing to that covered by our Clause 19, were ever designated as risky in the circumstances. Neither the Commissioner then nor the current Commissioner was of the opinion that any particular type of processing should have been so designated, and didn't envisage any circumstances in which any type of processing would need to be so designated in the circumstances. And as so for the entire period of the 1998 legislation, from 1998 to 2009, there was no designation of specified or accessible processing under their legislation, and that's the only reason that we could glean they perhaps would have removed it from the new bill or the new law that they had.
Okay, then should we remove this last sentence that MSED did not provide a response then?
I think we could now, Chair, just indicate that we have provided a response, but the decision would be that of the committee as to whether or not we would want to keep this particular provision to allow the Commissioner to designate a particular type of processing as being processing which is considered to be substantial, to cause substantial damage or distress or to prejudice the rights and freedoms of data subjects. As I indicated, the country from which we would have taken this particular provision didn't see any cause through its its information commissioner to have to make any such designation for the entire period that it was in their law or in its law.
Put it to the members.
The only reservation that I have is whether it's their culture, their situation that determined that it wasn't necessary. What would your recommendation really be, having done the research? Because we have different situations, and what you're emphasizing is the fact that they did not see any need. So I want to get a little bit more around that.
Member and Chair, certainly in looking at it, our recommendation is that they had the provision and the opportunity to make an assessment, and consequent on that, they didn't need to. If we remove it, then you remove the ability for the Commissioner to even consider circumstances in which such processing may be deemed necessary in our jurisprudence and our context. And so there is merit in keeping the provision and allowing as our jurisprudence and as our privacy regime develops, to give to the Commissioner this particular power to make the type of assessment that is provided for here, and then certainly upon review, if it is that the Commissioner, who I'm no doubt would inform any sort of review of the legislation, is of the view that this particular provision is unnecessary or superfluous, then we could seek to treat with it at that particular time.
What happened, Tristan?
Mommy, what is an activate?
Activate? Where you hear that word?
A lady was on the TV and she said she is a children's activate.
Oh, the advocate.
That's what I said.
Okay, the children's advocate is the person who makes sure that people know and respect the rights of children. She also makes sure that they are protected. She makes sure that even the government does its job properly when it comes to kids.
Children have rights too, Mommy?
Of course.
So, Mommy, do I have the rights to a little ice cream?
Right now, you have the right to go to bed.
Be an advocate for children's rights. An invitation from the Office of the Children's Advocate.
If you discover a large fire within a building, sound the alarm, leave the building immediately. Proceed to the assembly point. Ensure that the fire department is called and report to the person in charge of roll call. And don't return to the building unless instructed. Educate yourself.
No one is immune to mental illness. Your age, race, gender, social class, or economic status is no match for addictive behaviors, anxiety or eating disorders, depression, or schizophrenia. What is having a good social support system. As the saying goes, in times of test, family is best. Unfortunately, many are denied the benefit of the support of family and friends because of stigma and an oppressive silence around mental illness. Let's put an end to the silence.
Speak up. Speak now.
End the stigma.
Share your story.
End the stigma.
A message from the Ministry of Health and Wellness.
There's a long-distance relay that's still on. Many have taken it this far, each leg as important as the next, each challenge faced with determination. Now it's your turn to take the baton. People living with HIV and AIDS and those who are vulnerable need your commitment. It stands in the way of a better quality of life for all of us and our self-respect as a region. It stands in the way of victory in the fight to stop the spread of HIV. Reject stigma and discrimination. Get us to zero.
PBCJ is now the source of information about Indian culture. Watch Incredible India on PBCJ and learn more about their homeland, Indian mythology, religion, food, music, and dance. Join us Sundays at 3 p.m. and Thursdays at 7:30 p.m. for Incredible India.
Incredible India.
What happened, Tristan?
Mommy, what is an activate?
Activate? Where you hear that word?
A lady was on the TV and she said she is a children's activate.
Oh, the advocate.
That's what I said.
Okay. The children's advocate is the person who makes sure that people know and respect the rights of children. She also makes sure that they are protected. She makes sure that even the government does its job properly when it comes to kids.
Children have rights too, Mommy?
Of course.
So, Mommy, do I have the rights to a little ice cream?
Right now, you have the right to go to bed.
Be an advocate for children's rights. An invitation from the Office of the Children's Advocate.
Yeah. Subclause 5. A concern is expressed that the use of the term likely in the subclause would place an unnecessarily low threshold and an unreasonable obligation on data controllers. Members of your committee were advised that words similar to that used in the Alberta Personal Information Protection Act, that is, real risk of significant harm to, should be inserted. Your committee therefore recommended that the words likely to affect should be deleted and the words real risk of significant harm to be inserted. We also agreed that the words without undue delay be deleted and the words in a form, manner and time to be prescribed be inserted after the word shall. You all right with that?
Well, I think the comments of the Solicitor General are relevant here also because I've looked at the bill and I've noticed the language is slightly different. So for the report, we could make the same addition as you suggested before.
Yeah, so you could say along the lines, words along the lines, real risk of significant harm be inserted, something like that. Yeah. Clause 22, the first standard, subclauses 1 and 3. Members of your committee noted that one stakeholder expressed concern about the use of the word fairly in the subclause and the need for clarification regarding same. Another stakeholder was of the view that international obligations which were deemed to be obtained fairly should be stated and incorporated in local legislation. Your committee was advised that there was no need to clarify the use of the term fairly, since clauses 23 and 24 provided clarity in what could be described as fair. Furthermore, we were told that there was no need to define international obligations as suggested by the stakeholder, since there were internal processes that were utilized to review international obligations. Hence, we did not support the proposals made. Subclause 7.
Chair, if I might make, since we're on that paragraph, just propose some recommendations to the committee. So at the second sentence, which begins, another stakeholder was of the view, we're proposing an amendment, and I'll just read the amendment. Another stakeholder was of the view that since data obtained pursuant to international obligations were deemed to be obtained fairly, these obligations should be stated and incorporated in local legislation. So we're adding some words because we think that would give the clarity that the emphasis is not on the international obligations that are to be deemed obtained fairly, but rather the data that is obtained pursuant to or under those treaties or agreements or arrangements. So we think that those words would add some clarity to the sentence, and I can reread it if necessary.
What was it that the stakeholder was suggesting should be incorporated in the bill? The international obligations?
That we should outline, essentially that we should outline what those obligations are, and the comment would have been from
All
the...
right, let's move on.
But
I know I agree with your amendment, but I'm just saying that couldn't work.
Right.
It would triple the size of the bill. All right. Subclause 7. One stakeholder commented that subclause 7A limits the rights provided under, check out that in, or either under or in, but not both, subclause 4, which means that whenever the information was necessary for a legal obligation, the data subject was not to be provided with the required information. The stakeholder also noted that subclause 7B imposed a limitation on the rights of the data subject, and the limitation would not be known until sometime in the future. Your committee was advised that the exemption in the clause was not unique, since in most data protection regimes, I think, yes, there were exemptions to the right of disclosure to the data subject. For example, for purposes of national security or law enforcement. This clause provided one such instance where, by virtue of the provisions under other enactments or other compliance with other legal obligations, the data could not be disclosed. We were told that to prevent an ever-increasing list of circumstances which could arise to prevent disclosure to data subjects, per clause 22(7)b, that additional circumstances, when prescribed, should be made subject to parliamentary oversight via an affirmative resolution. Speaking for myself, Madam Chair, I find that paragraph difficult to follow. I don't know if it's because I don't understand the context, but I read it and I really don't know what it's saying, but others may be not so disadvantaged. Clause 23.
Excuse me, Chair.
Yeah.
Just on that note, the sentence was saying we were told, and it said what they were told, that parliamentary oversight via affirmative resolution would be necessary, but there's no conclusion recorded in the report. Did the committee accept that proposal? My recollection is that the committee did accept the proposal, but I think we should include it there.
Additionally, Chair and members,
Told by who? Who told us this? Or is it top secret? this is if we were going to add additional circumstances in which there would not be disclosure to data subjects. Those would have to be approved, as it were, by Parliament. Is that the point? Right. So I think that's a good idea. So we could just add the committee agreed with what they were told.
So member, that would have been a recommendation from the ministry in relation to that section. So I think we were the ones telling. One further edit that we're proposing in that sentence just before we were told. We believe that where it says, or other compliance with other legal obligations, that other should be for. So that it would read, or for compliance with other legal obligations.
Okay, clause 23.
Recommend that we change the we were told to MSET said.
Okay, clause 23, conditions for processing personal data in accordance with the first standard, subclause 1b. In respect of clause 23(1)b, we recommended that it be a criminal offense if a third party to whom anonymized data was transferred uses other information to de-anonymize the data, that is, to re-identify an individual. It was agreed by members of your committee that the fine for the offense of re-identifying anonymous data should be set at a ceiling of $2 million on summary conviction in the parish court, and for conviction and indictment in the Supreme Court, the person will be liable to a fine to be determined by the judge based on the gravity of the circumstance. Subclause 1d. In relation to the use of the term vital interest in the provision, your committee noted that there was no need for the term to be defined in the bill, and based on a general review of the literature, the term was limited to life-threatening circumstances where there was no other legal ground for processing. Subclause 1e3. We noted during the committee's consultation that concerns were raised about the exemption of the government and it appearing to be a significant loophole to public authorities in the processing of data for the administration of justice. We concurred that the provision was wide and therefore recommended the deletion of 23(1)(e)(3). New subclause. Your committee noted from clause 10(2) the grounds under which data subjects could request that a data controller cease processing his or her data. However, we recommended that a right be inserted in clause 23 to allow data subjects to indicate to a data controller that he or she wishes to withdraw consent and there was no longer a right to process his or her data. Clause 24, conditions for processing sensitive personal data in accordance with the first standard. We supported the recommendation that the words sensitive.
If we may, Chair, I'm so sorry to stop the member. We're just conferring, Chair, with respect to subclause 23(1)(e), and we wanted to put for the committee's consideration some language that we believed would assist in bringing further clarity. Currently, the way it's drafted, the reference suggests that the comment was in relation to 23(1)(e)(3), when I believe that when we checked back our records, the stakeholder was drawing comments generally on subclause 23(1)(e), not necessarily on 3 alone. And so we have proposed some alternate language, which reads as follows. We noted during the committee's consultation that concerns were raised about the apparent exemption afforded to government to be deemed to be processing data fairly and lawfully when that processing is necessary for the administration of justice and generally by the government under clause 23(1)(e). And then it would go on to indicate we concur that the provision was too wide and recommended deletion of one of those circumstances, which is 23(1)(e). 1E3, I'm so sorry, 1E3. So the language would read, we delete words after, in the first sentence, the words that follow from concerns were, we would delete everything from raised to administration of justice and replace it with words which read, the concerns were raised about the apparent exemption afforded to government to be deemed to be processing data fairly and lawfully when that processing is necessary for the administration of justice and generally by the government under clause 23(1)(e).
But in the bill, the revised draft, some words were deleted, but other words were inserted in their place.
A renumbering of what was 4 before.
So the words, the amendment we're recommending is as follows, that we delete the words after concerns were, that is anything following after were all the way to administration of justice, and that we replace that sentence or those words, I'm sorry, as follows, starting that concerns were raised about the apparent exemption afforded to government to be deemed to be processing data fairly and lawfully when that processing is necessary for the administration of justice and undertaken generally by the government under clause 23(1)(e).
I notice in the revised bill in 2 and 3, E2 and E3, the words, well, conferred on any person in 2 and by any person in 3. And I'm not sure why we need those words. But that's just a comment for the drafter to think about. Can I move on?
Yes. Just one further one. At the subheading new subclause, we're proposing your committee noted that clause 10(2) provides the grounds under which data subjects could request that a data controller cease processing his or her data. So the insertion of the word provides.
Rather than go through all these drafting edits, which is, given the preciousness of time, can we kind of stick to the substantive issues and just leave it to you all to tidy it up, language-wise? Yeah, because I think there's a lot of improvement that could be made to what's in here. Some of them it's quite obtuse if you're just reading it and you don't know the context. So I'd be quite happy to have the report improved from that standpoint without having to hear every suggestion here. But the substantive issues I think we need to sign off on as a committee. Where am I now? New subclause? 24? 24, conditions for processing sensitive personal data in accordance with the first standard. We supported the recommendation that the word sensitive personal data should replace the words personal data throughout the clause, given that the clause relates to sensitive personal data. Subclause 1G3, given that this subclause was similar to 23(1)(e)(3, we recommend the deletion of same. Or we could just say we recommend its deletion. Less legalistic. Clause 25, the second standard. Your committee recommended that no amendment was necessary for this clause. Clause 26, the third standard. We noted the concerns that words such as excessive, adequate, relevant, and relevant were ambiguous, and the proposal that the Commissioner should publish guidance notes to clarify the way in which the term excessive was to be interpreted. Your Commission agreed that the words not excessive in relation to the purpose should be deleted, and the words along the lines limited to what is necessary for the purposes should be included instead. Clause 27, the fourth standard. We observed that a suggestion was made that an obligation should be placed on data subjects to keep their data up to date. We were advised that no jurisdiction placed this obligation on data subjects, and hence we recommended that no amendment was necessary for this clause. Clause 28, the fifth standard. Although your committee recommended that no amendment was necessary for this clause, it was noted that MSET will take into consideration when drafting regulations for the proposed legislation the record-keeping requirements under the Proceeds of Crime Money Laundering Prevention Regulations 2007, the Banking Services Deposit-Taking Institutions Customer-Related Matters Code of Conduct 2016, and the specific retention period for which data is processed. Clause 29, the sixth standard. Your committee recommended that no amendment was necessary for this clause. Clause 30, the seventh standard. This clause provided that appropriate technical and organizational measures should be taken against unauthorized or unlawful processing of personal data and against accidental loss or destruction of or damage to personal data. Stakeholders suggested that the provisions could be more robust as they appeared to be inadequate. We supported MSET's view that greater clarity could be given to the technical and organizational measures which were required to be taken by data controllers, and the recommendation that similar language be adopted from Article 32 of the GDPR and the UK's Data Protection Act 2018.
Excuse me, Chair, just on a note of clarification regarding Clause 29, where you said the committee recommended that no amendment was necessary for this clause. In looking at the bill, I realized that 2 amendments were done to Clause 29, but that was because it was a consequential amendment because of the proposed amendments to Clause 10 and 11. So just for accuracy, I'll just ask that that be noted.
No substantive amendment then? Since the other is really just for referential coherence. Clause 31, the eighth standard. Concerns were raised about the transfer of data to other territories outside Jamaica. One particular recommendation was of note, was that a list of territories that had adequate protection should be provided. The committee recommended that the scheme as reflected in Article 28(3) of Malta's Data Protection Act 2002, which provides that the Commissioner may authorize a transfer or set of transfers of personal data to a state or territory that did not have the adequate level of protection, provided that the data controller had adequate safeguards, which may result particularly by means of appropriate contractual provisions. There's a verb missing in that sentence, I think. It was also agreed that the clause be amended to allow an exemption for cross-border transfer of personal data in instances that were related to intelligence, investigations, or law enforcement. Part 5. Exemptions to data protection standards or to disclosure to data subject requirements. Is that correct? Seems a word might be missing there or something. Clause 32, interpretation for part 5 rather. Your committee recommended that no amendment was necessary for this clause. Clause 33, national security. Although we noted the concern about the Minister of National Security issuing the certificate of exemption for the purpose of safeguarding national security, your committee recommended that no amendment was necessary for this clause, as we were advised that the concept of allowing exemption on the grounds of national security was not a new concept of how information was accessed and disclosed. Clause 34, law enforcement, taxation, statutory functions, etc. Members of your committee recommended that wherever in the clause or the bill the prevention and detection of crime were addressed, the word investigation should be inserted. When we say members of your committee, is that like not a recommendation of the committee? Yes. But by saying members, it suggests like some, but not all. You know, wouldn't we just normally say your committee recommended? Yeah, yeah. Your members. Okay. Well, then the members. Well, yeah. I think we should just say your committee. Your committee is, like on page 12, for example, Chair, if you look under clause 15 in the middle of the page, it was brought to your committee's attention. You know, it's that your committee is a normal, yeah. Yes, just say your committee. All right, where are we? Okay, 35, clause 35, health, education, and social work. This clause suggested that the minister may, by order, exempt from disclosure to data subjects requirements or modify requirements. Is this correct where it says exempt from disclosure to data subject requirements? Is that correct, that formulation? Yeah, okay. Or modify requirements in relation to personal data, such as information related to the physical or mental health of a data subject. We supported the recommendation that the clause be deleted, since there should be no exemption for withholding health, education, and social work information from data subjects. Clause 36, regulatory activity. This clause provided that personal data processed for the use of discharging any function should be exempted from disclosure of data requirements to the extent that the information would likely prejudice the proper discharge of those functions. Is that suggesting no amendment is necessary? Or is this an attempt to summarize what the clause says? I don't think we need to summarize what clauses say, though. I think it's just, you know, if no amendments needed, unless you're commenting on it in some way, but if it's just a summary, I don't think it's necessary. Could they say your committee recommended no amendment was necessary for this clause? Yeah. Subclause 2A2. We support the recommendation made that clause 36 2A2 be deleted, as the functions to which it referred were captured in the functions outlined in the other provisions in the clause. So, okay, so it's that. I see. So maybe the subheading, I don't know, the way it's laid out is confusing. Anyway, it confused me. Clause 37, journalism, literature, and art. Stakeholders raised concern about this clause on the basis of journalism. We observed that it was recommended that the clause be deleted, as it placed the commissioner in a superintending role. I don't think you need the hyphen there. Regarding the practice of journalism, to determine whether publication would be in the public interest. Clause 37(1)(b) should be amended to read that personal data which are processed only for the special purposes were exempt from the provisions specified in subsection 2. And clause 37(1) should be amended to make it clear that the exemption protections apply to pre- and post-publications. We did not support any of these recommendations. Members expressed concern about the grouping of literacy and artistic purposes with journalism and felt that journalism should be separate, given the constitutional guarantee for the freedom of speech and expression that relate to journalism. However, we found that no jurisdiction treated with the matters separately, and that the court, in making a judgment in relation to journalistic, literary, and artistic matters, would consider the purpose of processing. On this advice, we did not feel, that there should be amendment to separate journalism from artistic and literary works. However, we recommended in clause 37(1)(b) the following words should be included after the word expression, in quotes, or the right to seek, receive, distribute, or disseminate information, opinions, and ideas through any media. So, if you want to say words to the effect of some such language, since we're not supposed to tell the drafter how to draft. Clause 38. Research, history, and statistics. Your committee recommended that no amendment was necessary for this clause. Clause 39, temporary exemption for manual data held by public authorities. Your committee noted that Clause 39 offered temporary exemption to manual data that forms part of an accessible record or is recorded information held by a public authority for a period of 2 years from the date of commencement of the bill. We noted that data was exempted from the 1st, 2nd, 3rd, 5th, 7th, and 8th data protection standards. The 6th data protection standard, except so far as that standard relates to the rights conferred on data subjects by clauses 6 and 7, clause 613 rather, clauses 10, 11, and 12, part 3 of the bill, clause 63, and clause 71, liability for damage. We supported recommendations that the clause be deleted and removed to the transitional provisions, and that the exemption period be extended to 2 years for private and public entities. Clause 40, information available to the public by or under any enactment. Your committee recommended no amendment. Clause 41, disclosures required by law or made in connection with legal proceedings, etc. Your committee recommended no amendment. Clause 42, parliamentary privilege, same. Clause 43, domestic purposes, same. Clause 44, miscellaneous exemptions. We did not support the recommendations that financial records should be included in the miscellaneous exemptions outlined in the 2nd schedule, and that provisions be made in the 2nd schedule to exempt the FID from the requirements of the bill. Hence, your committee recommended that no amendment was necessary for this clause. Is that right? Clause 45, power to make further exemptions by order. Your committee recommended no amendment. Part 6, enforcement. Clause 46, enforcement notice. Your committee recommended no amendment. Clause 47, data protection impact assessment. Members of your committee raised concern about whether all data controllers would be required to carry out an impact assessment report, and felt that the commissioner should be given power to determine the entities that should do so. On one hand, one member suggested that size of businesses as well as the capital turnover of these entities, I don't think it's capital turnover, is it? Yeah, revenue or turnover, yeah, of these entities should be a factor to consider in determining entities that should file an assessment report. Another member said that the size of the business should not be a factor, since some small enterprises collect important personal data. These concerns were in line with the concerns raised by stakeholders, with one stakeholder suggesting a phased implementation of the bill with this clause coming into force 1 year after the relevant forms were published in the Gazette. After a lengthy discussion, members agreed to the following. The Commissioner should be able to specify the classes or kinds of data or data controllers that were required to comply under subclause 1 to submit a data protection impact assessment. I think this should apply to registration as well. That's my view. There should be a new subclause 3 which specify the minimum information that should be included in the data protection impact assessment. A new subclause 4 should be included to enable the Commissioner to publish a notice in the Gazette and any other medium appropriate. Medium? Yeah? Media? Appropriate in order to bring to the attention of the public the classes or kind of data or data controllers who are required to comply with the requirement to submit a data protection impact assessment. There should be a new subclause 5 providing the factors that the Commissioner should take into account in determining the classes or kind of data controllers who are required to comply with the requirements. Considering these recommendations, we agreed that subclause 1 be amended along the following lines. Quote 1. Unless otherwise specified in a notice under subsection 4, a data controller shall, in respect of each calendar year, A, within 90 days after the end of the relevant calendar year, or is it preceding calendar year, perhaps? After the end of the preceding calendar year. Yeah, anyway, and B, in such form as may be prescribed by the Commissioner by notice published in the Gazette, submit to the Commissioner a data protection impact assessment in respect of all personal data in the custody or control of that data, of the data controller. New subclauses 3, 4, and 5 should be along the following lines. 3. The data protection impact assessment form prescribed under subsection 1 shall require at least the following information. A detailed description of the envisaged processing of the personal data and the purposes of the processing, specifying where applicable the legitimate interest pursued by the data controller. B, an assessment of the necessity and proportionality of the processing operations in relation to these purposes. I'm just trying to imagine like a small church in my constituency reading this and wondering, what is more, it's more complicated than this section of Corinthians that I have to read at funerals. An assessment of the necessity of and proportionality of the processing operations in relation to the purposes. C, an assessment of the risks to the rights and freedoms of data subjects referred to in paragraph 5. And D, the measures envisaged to address the risks, including safeguards, security measures, and mechanisms to ensure that the protection of personal data and to demonstrate compliance with this Act, taking into account the rights and legitimate interests of data subjects and other persons concerned. 4. The Commissioner may publish a notice in the Gazette, and in such other manner as the Commissioner considers appropriate, to bring the notice to the attention of data controllers, specifying the classes or kinds of personal data or data controllers to which subsection 1 shall apply or not apply. 5. In determining any class or kind for the purpose of subsection 4, the Commissioner shall have regard to the likely level of risk to the rights and freedoms of data subjects involved in the processing the data concerned, taking into account the nature, scope, context, and purposes of the processing. Okay. Chair, could you remind me, in relation to this registration requirement that is being imposed on all data controllers, did we have any provision that would allow the Commissioner to approach the matter in a similar way to how this data impact assessment is being approached? In other words, where for firms or persons who might find registration onerous, or where the capacity of the Commission to cope with that volume might not be realistically present, the Commissioner could, as it were, establish classes or kinds of controllers to which the registration requirement might not apply.
Okay. My recollection is that we were saying full registration in the beginning just to ensure that the commissioner had some data, right? And then after that, they can determine who gets assessed or not. That was my recollection. Ms. Murray, yeah.
Specific response to the member's question. In the draft bill at clause 15, that edit was made to empower the commissioner after consultation with the minister rather after consultation with the commissioner and subject to affirmative resolution, determining the data processors that would not be required to register.
Approach consistent with this? Because this seems like quite a good approach.
To register, Ms. Murray? To register?
Yes.
Is that a change? Because I thought we were saying all entities would be required to register initially.
All?
Initially.
But when
Just
you say
so
initially, you mean they might deregister afterwards?
From the get-go, so that the controller would have information, would have a benchmark of information.
Operationally, but with respect to the amendments, and I'll be guided by the SG and the CPC on this, the power to actually exclude a set after that period is what has been made. The amendments have been made to allow for that, but operationally, yes, and in practice.
What do you mean, operationally, yes? After what period?
The legislation doesn't specify a period, so if it is that the members would want the legislation to specify a period, I suppose that would have to be included specifically. Otherwise, the scheme here is that the minister and the commission, well, the minister really, after consultation with the commissioner, can, subject to affirmative resolution, determine after a period of time, minister, so that would be like a year or 2 or 3, as determined by the minister, who should be excluded from registration. So without specifying a time, the minister really is the one that would be coming to Parliament after consultation with the commissioner.
But the minister could do this up front.
Could,
yeah.
Yes.
Because registration attracts a fee and all kind of thing, right?
How would you know up front who needs to register?
Well, you could take the approach, for example, that you're going to process substantial operation. You're going to register substantial data controllers first. So you could have, for example, a size threshold initially, so that any enterprise that has more than X number of employees or a turnover of more than X dollars per year must file. I mean, and then you could look at, see what volume comes in, and you could say, okay, we want to make it more expansive, and therefore adjust those or eliminate those altogether. But I just, given how widely the bill defines what a data controller is, it includes in its net real mom and pop operations and non-profit operations and so on. And
remember we had said that you could have a small entity that's still collecting valuable information, right?
So to the extent that there is a class that fits that description, they could be excluded from the exemption. But I just feel fairly strongly that for a huge new bureaucratic requirement and costly one to be imposed on very small economic actors is undesirable. But that's my view, Minister. Obviously, ultimately, it's the ministry's bill, your bill, but I raise it because I want to understand how the bill is approaching this matter. And at least it has an avenue by which the minister can address that, his or her mind to that issue, and decide what policy they want to adopt, whether it's going to be comprehensive full registration for everybody who's a data controller, or some other formulation which can be adjusted over time. And the bill facilitates that, which is really what I wanted to ensure of myself of. Where was I? Right. 48. Request for assessment. Your committee recommended no amendment. Clause 49, assessment notice. Based on the concerns raised by the National Identification System Project Unit that the provision of the clause might lead to a compromise of personal and identity information contained in the National Civil and Identification Database or by other data controllers during compulsory assessments, and that the bill failed to set out the factors that will inform the Commissioner's decision to serve an assessment notice, your committee recommended that a provision be included in the bill to require the Commission to prepare and publish a specific code of practice governing assessment notices. Additionally, we agreed that there be guidelines for the Commissioner to publish and issue assessment notices with reasons, and that a similar language, I think, and that similar language, take out the to the provision on Code of Conduct for Assessment Notices in the UK Data Protection Act 1998 be adopted. Clause 50, limitations on assessment notices. Your committee recommended no amendment. Clause 51, information notices, same. Clause 52, determination by commissioners to the special purposes, same. Clause 53, restriction on enforcement in case of processing for the special purposes, same. Clause 54, failure to comply with notice, subclause 4. Your committee recommended that the fine of $500,000 be increased to $1 million. Clause 55, rights of appeal. Your committee recommended that no amendments necessary. Clause 56, determination of appeals, same. Clause 57, powers of entry and inspection, same. Part 7, miscellaneous and general. Clause 58, reports and codes of practice to be laid before Parliament. Your committee spent a few meetings deliberating on mandatory codes, codes of practice, and codes of conduct. Huh? That's all we did for a few meetings. Our concerns were that there would be no legal liability for a breach of codes, especially for those codes that were mandatory. And there was a lack of coherence in the approach of some codes being required. I think we should rather say a few meetings, we could just say considerable time. Yes. Or fulsomely. Yeah, some such language, right? And there was a lack of coherence in the approach of some codes being required to be tabled, while other codes were subject to affirmative resolution of both houses of Parliament. We found out that based on the provisions of data, we were advised that based on the provisions of data protection legislation in the UK, Isle of Man, Jersey, and Bermuda, non-compliance of a code or with a code was not considered an offense, while in other jurisdictions an offense is created for a breach of a code. However, we noted that Trinidad and Tobago's Data Protection Act 2011 made reference to mandatory codes and voluntary codes, and there was provision which states that where the Information Commissioner was of the opinion that mandatory codes should be developed in the public interest, he or she could by order require the development of a code of conduct and set a time limit for its development. Who would develop it? Not the Commissioner? Kind of strange. He could require the development of a code and set a time limit, so you could like instruct the ministry to do it or something? From the industry, is it? From the public or the section of the public? I see. Yeah. We were particularly referred to Section 74 of Trinidad and Tobago's legislation, which made provision that where the Commissioner had approved a code of conduct, the Minister could, by order, make compliance with the code mandatory. We learned that an offense was created if there was failure to comply with the mandatory code of conduct. Members of your committee recommended that the word code should be used to refer to measures that were legally binding, and the word guidelines should be used for measures that will not be legally binding but relevant for the regulatory assessment of conduct. This means that mandatory codes and voluntary codes of practice should be referred to as guidelines, and data sharing codes, which all data controllers were required to adhere to, should be referred to as codes. Right, so the non-binding ones we refer to as guidelines rather than codes, and the binding ones we refer to as codes. That's essentially what that's saying. Clause 59, data sharing code. This clause addresses the preparation of data sharing code, but I think like data sharing code or codes, I don't know. This is not code like software, right? Yeah. Yes. Except the data sharing code, which we're going to keep as a code because it's meant to be binding. This clause addresses the preparation of a data sharing code or data sharing codes by the Commissioner and the submission of the code to the House of Parliament for affirmative resolution. The recommendation with respect to Clause 58 is applicable to this clause. Clause 59.2, we endorse a recommendation made by one of the stakeholders that Clause 59.2 be amended to include that persons who appear to the Commissioner to represent the interests of data controllers be consulted with in developing the data sharing code. Clause 60, effect of data sharing code. Your committee recommended no amendment. Clause 61, assistance by Commissioner in cases involving processing for special purposes. One member of your committee inquired as to whether I wonder who that was. One member of your committee inquired as to whether the Commissioner had locus standi to intervene in any proceedings, especially those relating to the interpretation of provisions of the bill. We were advised by the AGC that based on Part 56 of the Civil Procedure Rules 2002, any statutory body could be a party of proceedings, or I think to proceedings, or could intervene in proceedings, I don't know what that's supposed to say, for any subject matter that would fall within its statutory remit. We were told that the Office of the Commissioner as a body corporate would be a statutory body and data protection matters would fall within the Commissioner's remit. Your committee recommended that no amendment was necessary for this clause. I actually thought we should make it clear that the Commissioner could intervene rather than leave it to the interpretation of the CPR. But maybe that was a figment of my imagination. Clause 62, international cooperation. Your committee recommended no amendment. Clause 63, I would just add that generally speaking, in such matters, it is worth making these things clear, especially when it comes to rights to appear in matters before the court. We've had some very bizarre decisions, in my opinion, in relation to circumstances in which the public defender, for example, can intervene in constitutional litigation. So I think it ought to be made clear if it's intended that the Commissioner should have the ability to intervene in those matters. I don't know how the committee feels about that. Committee seems to like it. All right. So we can ask the author or authoress of the report to tweak that. 61, yes, ma'am. Clause 63, unlawfully obtaining, disclosing, etc. personal data. Subclause 2A1. One member of your committee expressed concern about subclause 2A1 being an unusual provision since it would allow any person to obtain information, and that person indicating that the basis for doing so was for the prevention or detection of crime. This, the member indicated, could pose a problem. The AGC advised that the provision should be deleted since no rationale could be provided by MSET for the inclusion of same in the bill. What did the committee feel about it? Did the committee agree with the advice given? I just think the report should say so if that's what happened, you know. Yeah. Can hardly imagine us not, but from the immutable advice of that profound source. Clause, well, can we just add the committee agreed or something like that? Clause 64, power of commissioner to impose fixed penalty. We recommended that the clause be amended to allow for the fixed penalty notice to be a summons. We were advised by the AGC that this would allow the clause to be consistent with other legislation. Subclauses 5 and 6. We agreed with the recommendation that the time period in subclauses 5 and 6. By the way, subclauses are in brackets. So subclauses 5 and 6. Yeah. And that's throughout. All right? Be changed from 15 days to 30 days to allow more time for data controllers to fully assess the penalty and potential avenues for recourse. Clause 65, your committee recommended no amendment. Clause 66, the same. Clause 67, disclosure of information. Members of your committee, not just one member this time, members of your committee and stakeholders expressed similar concern about the wide power granted to the commissioner to be able to, notwithstanding any enactment, require information from any data controller. We found out from MSET that yes, MSET advised that some countries in their data protection legislation had similar provisions to that of Clause 67, while some countries expanded the section of their legislation to take into account matters of national security and safeguarding the security of the country or information privileged from disclosure in court proceedings. We found out that some matters, such as information before the court, legal professional privilege, which was a fundamental right that was inviolable, and national security should be considered. We found out that these should be considered. Having considered the matter, your committee recommended that the provision be amended to include appropriate exemptions to the provisions. Did we say what the appropriate exemptions should be? Is it intended to be those that were referred to, which namely were legal professional privilege and national security? Is that it?
Wasn't it just national security?
67.
The amended provision is now what's in renumbered section or clause 65 of the draft. I think my pages might be different. 90 or 91? Right. Renumbered as 65, clause 65. Where the provision now is made for exclusions. We are precluded from disclosure under any enactment or rule of law, or in subsection 2,
Nothing in subsection 1 shall be construed as requiring an individual to disclose A, anything that tends to incriminate that individual, or B, any information protected from disclosure by legal professional privilege. So those would be the 3 exceptions.
And when we say incriminate there, we kind of mean incrimination in the context of potential criminal liability. Yeah. All right. Okay. 68, confidentiality of information. We recommended that the clause be amended to include a provision about the perpetual confidentiality of information, even when staff of the Office of the Commissioner demits office.
Chair, if I might, members, this was a concern that was raised, but I believe the CPC would have clarified or rather pointed out that the provisions the provision as it is, which is renumbered 66, treats with that issue already, because it says no person who is or has been the commissioner, a member of the commissioner's staff, or an agent shall disclose.
Right, okay. So that, for 68, then we can simply say your committee recommended no amendment. Clause 69, prosecutions and penalties, subclause A and B, I think, 1A and B. A proposal was made that redress for individuals must be included, and this right must not be conferred only upon the legal fraternity or the Director of Public Prosecutions. We were advised by MSET that the clause refers to criminal charges that would be brought by the police and subsequently dealt with by the DPP. We found out that individuals were able to bring a civil suit against any person who they believed was in contravention of the bill with regard to their personal data by virtue of clause 71. Your committee recommended that no amendment was necessary for this clause. Clause 70, liability of body, corporate directors, etc. Subclause 1. The main concern that was raised for this clause was in relation to the 10% fine of the annual gross income of a body corporate, which was considered exorbitant. A suggestion that was made was that the precise sum of less than 10% of annual gross income should be set for the fine. It was pointed out to members of your committee by Representative MSET that the fine of 10% of annual gross income represented a maximum fine, and the court would assess, based on guidance provided in the clause, the fine that would be applicable. Members of your committee supported the 10% fine and seemed to be in general support for a worldwide annual turnover as used in the GDPR instead of the gross income of a local subsidiary. It was of note that one of your committee cautioned that consideration should be made about a total worldwide annual turnover, since this could have implications. Based on the advice provided to MSET by the Tax Administration Jamaica, we were informed that language to the effect of gross annual turnover for the preceding year of assessment in accordance with the Income Tax Act would be administrable, since TAJ currently assessed worldwide annual turnover of companies incorporated in Jamaica. This seems to be dealing with two different things, though. I mean, I think the comment in the middle about worldwide annual turnover as used in the GDPR instead of the gross income of a local subsidiary, I think that seems to suggest that the concern was whether the turnover of the corporate group, its worldwide turnover, should be considered as opposed to a local subsidiary's turnover. Whereas what is proposed by the TAJ would apply to the worldwide income of the local subsidiary and not of the group. Well, that's just how tax law works. We don't have
Worldwide income of the local subsidiary only?
In other words, they're making the point that taxpayers in Jamaica who are liable to income tax, whether they be corporate or individual, are liable to tax on their worldwide income. That's how our system is. I don't think that addresses the concern that was raised earlier, which is that the entity whose worldwide income is being looked at for the application of this 10% fine as a maximum might be a very small part of a larger group, and that the GDPR approach, based on what I'm inferring from this, would have looked at it more in the round and taken into account not just the Luxembourg subsidiary of, massive worldwide company, but you'd look at the parent, or at least the group as a whole, and in determining that limit. I don't know if that's so, but all I'm saying is that if that is the case, the fact that you're going to look at the worldwide income of the entity isn't really taking the matter any further, because when you talk about gross income, that's what you mean. Gross income of a body corporate would mean it's gross income, whether it's earned here or there or anywhere. The question really is, should this fine apply to not just the gross income of the infraction, the party that committed the local infraction, or should it be a situation in which, if it is part of a much bigger group, it would be the group's income that you take into account? I don't know. I don't know how the GDPR deals with it. If they are entity specific, or if they look at the enterprise as a whole of which it may form part.
Ms. Murray, when you spoke to THA, did they specifically say annual turnover of companies incorporated in Jamaica?
Yes, Chair. Looking back at the comments that they made, and the comments were that in recommending the edit, or the proposed language rather, they noted that it would be administrable and would be equivalent to the worldwide turnover of companies incorporated or resident in Jamaica. However, they went on to say that for branches or permanent establishments that are only registered and not resident for tax purposes, it would be equivalent to income attributable to Jamaica.
That's from a tax perspective, yeah. I mean, if you have a branch in Jamaica, and you haven't incorporated a separate subsidiary, under double taxation treaties, the Jamaican tax authority will tax its Jamaican generated income. So, Citibank, for example, which is a branch of Citibank NA, pays income tax in Jamaica on its Jamaican business, not on the worldwide business, because under the double taxation treaty, that's how it's addressed. But I got the impression that the concern of the member was that supposing you have, a big multinational that forms something here, and there's a violation which the party is to be fined for, is it of that relatively tiny part of its worldwide operation that the 10% would be the limit attached to? Or would you be able to pierce the veil and look at the enterprise as a whole in fixing the fine? I don't know if there's precedent for approaching it that way in the GDPR. That's really the question I'm asking.
Chairman and members, I can read the provisions in the GDPR. It provides that infringements of the following provisions are subject to administrative fines up to 10 million euro, or in the case of an undertaking, up to 2% of the total worldwide annual turnover of the preceding financial year, whichever is higher, and then it lists the provisions. But that's it.
So it's entity specific, like you know, and but it's 2% rather than 10. Why are we at like 5 times higher as a limit than the GDPR?
Remember,
Yeah.
we actually looked at the Trinidad legislation for this, not the GDPR.
Just to say that for most companies, a fine of 10% of gross income is a closed down business kind of fine, you know, because margins are up to up to. I hear you, but you know, why not? Why set the cap 5 times greater than the Europeans have? I don't know, because the Trinis did. You know, they're known for their excesses.
If, as I recall, we wanted to impact total global income, then the percentage could be reduced, right? To the 2% as per the GDPR.
GDPR is 2% of total worldwide income, or a fixed sum, whichever is less or greater. I can't remember. The GDPR, is it the fixed sum or the percentage of worldwide income, whichever is greater, whichever is higher? Okay, it's 2%. There, we are saying 10% of gross income, of annual gross income, which is worldwide income. You know, we're not saying limited to income made in Jamaica or anything. Yeah, I'm just saying the 10% is a big number, and you can compare to, you know, what gross profit is, and then net profit is from, you know, if you were to say what percentage of gross income net profit represents, it's a small percentage usually, you know. So it might be more than a year's profit that they're paying as a fine. You know, it might be. Anyway, I just wasn't sure why we are so much higher than the GDPR, but I'm told because, you know, where Trinidad sails, Jamaica follows.
No, remember, just to share also that what the GDPR did was actually they had two different sets of schemes rather. So there was 2% and 10 million euro on breaches of a particular kind, and then there was a 20 million euro or up to 4% on another set. And that 4% was would be applicable to breaches of the data subject's rights and breaches of certain principles within the GDPR. So still less than 10, but they did go up to 4.
Yeah, less than half of 10.
All right. So committee, I mean, sounds like a change is required. We're going to move it from 10 to 2%.
I'd be inclined to.
And make it global, right? Truly global income.
Yes.
Yeah.
I mean, it says gross income. You could say, you know, if you want to make it clear, you could say both in Jamaica and outside, or, you know,
Wherever
wherever it is.
Yeah. The decision that I put to committee members is that we move the sum from 10% of global gross income to 4%, and that we stipulate that it is worldwide income regardless of where the company is incorporated, or regardless of where it does business, regardless of where it generates revenues from.
Since that differs from the tax situation. So, you know, if they establish a permanent establishment here, it is not 4% of the worldwide income of the permanent establishment. It is 4% of the worldwide income of the legal entity of which that permanent establishment happens to be a branch. So that's a significant difference from the way in which the tax legislation treats with this. But is more protective of our citizens. All right, so I hope that's been absorbed. Clause
So
71.
I put clause 70 to the committee. Clause 70, no?
I don't think we're just going through the report.
All right.
Yeah. Clause 71, liability for damage. We noted that concerns were raised about the use of the term damage, a person being precluded from being able to recover damages under the bill and the Defamation Act, and a specific period being established for which claims for compensation could be brought before a court by a claimant. In respect of damages, the AGC advised that the policy of MSET had to be considered. MSET pointed out that provision relating to damage should be determined by the court, and the data protection jurisprudence would need to evolve in Jamaica. We were told that the defamation jurisprudence was developed differently from that of data protection. And defamatory awards, awards for defamation, were usually considered excessive. And sections 23 and 33 of the Defamation Act address the issue of damages and limitation period for action, respectively. Your committee recommended that no amendment was necessary for this clause. You know, sometimes I think if we're not recommending an amendment, it's not particularly helpful to attempt to summarize what may have been a fairly long and complex discussion, because when you read it, it doesn't often doesn't flow very well. Clause 72, appeals. Your committee recommended no amendment. Clause 73, services of notice, same. Clause 74, application to the Crown. Stakeholders raised concern about the Crown being excluded from liability for prosecution. We were advised by the AGC, as a matter of legal theory, the Crown can't be prosecuted because prosecutions are brought in the name of the Crown. The Crown versus the Crown. Yes, all right, sorry. We were advised by the AGC, skip to the end. All right, no amendment was necessary. I thought we might be entertained by reading the discussion here, though, because it sounded like it was heading in an interesting direction. All right, Clause 75, application to Parliament. Your committee recommended no amendment. Clause 76, regulation, subclause 1. We recommended that the letter S be added to the word provision in subclause 1A, and the word provisions should be included after the word savings in subclause 1B. Clause 77, transitional, subclause A. We recommended that the period of 1 year in subclause 1 should be changed to 2 years. Insertion of new provisions, right to data portability. We support the recommendation of stakeholders that data subjects should be given the right to obtain and reuse their personal data in ways they choose across different services and between different companies. Review of the bill once enforced. Your committee agreed that a provision be included in the proposed legislation for it to be reviewed every 5 years, starting from the date of its commencement. Would it be every 5 years or within 5 years and thereafter? I mean, it's kind of unusual to require it to be done every 5 years by statute. You normally require it to be reviewed within a specified period, and then subsequently, from time to time, it's a need may arise. New criminal offense. We recommended there should be an offense.
So what is the decision of the committee?
Is there a formulation for that we use?
Yes, there is.
Well,
and we don't usually put the subsequently, because Parliament can always determine thereafter
if they want to have it reviewed. Yeah.
But usually the first one
is specified. Yeah.
Is set out in.
So within 5 years, okay. And it's of the commencement date, it would be, right? Normally it would be of the first commencement date, because you might have multiple dates, right? New criminal offense.
I'm sorry, before you move on, could we just go back to where we were dealing with clause 76? In subclause 1, there was a recommendation that the letter S should have been added to the word provision in subclause 1A.
Yeah.
I think that it was correct in the singular. It's now the renumbered section or clause 74, which deals with regulations.
Minister may make regulations for the purpose of giving effect to the provisions of this Act, and such regulations may A, make different provision for different cases. So it's correct in the singular because it's really one provision that would be made for each different case and not multiple provisions for one single case. So the singular is actually correct and not the plural.
Fine. Yeah. Your committee recommended no amendment. Yes. Okay. And that has been done, right? Okay. New criminal offense. We recommended that there should be an offense for the destruction or alteration of records to prevent the disclosure to data subjects of information following a data subject access request. Schedules. First schedule and appendix to first schedule. Paragraph 2. Your committee recommended that the commissioner should not hold office more than 2 terms, and that he or she should not hold office for such term not exceeding 7 years, or should hold office. Is the idea that there should be a 7-year maximum? Yeah. So, yes. So it's 2 7-year terms is a maximum? That's what we're proposing? Or up to, not exceeding 7 years. You could appoint them for less? Yeah. We did not support the retirement age of 65 for the commissioner. Considering these amendments, we agreed that A, the word 5 in paragraph 2.1 of the first schedule be deleted and the word 7 be inserted instead. B, the words in the paragraph 2.4a of the first schedule be deleted and the words on completing one term be inserted instead. C, the word 10 be deleted in paragraph 2.4b of the first schedule and the word 14 be inserted instead. D, the words in paragraph 2.3.1a of the appendix to the first schedule be deleted and replaced with the words on completing one term as commissioner. E, the word 10 in paragraph 2.3b of the appendix to the first schedule be deleted and the word 7 be inserted instead. F, a consequential amendment to paragraph 4 of the appendix to the first schedule be done, since the reduced pension in same would link to the age of retirement and would need to be linked to the completion of the term or a shorter period.
I have a query. Back to page 26.
Mm-hmm.
It starts out with saying your committee recommended. Was it that the committee made these recommendations? And then it goes on to considering, so what I got from that paragraph is the committee made recommendations to the committee and then the committee considered those recommendations and agreed as follows? Was it the committee that proposed these
The
changes?
committee was of the view that the commissioner should not hold? Considering this, your committee recommends
Was
that.
it the committee would have made the recommendations or a member of the committee made a recommendation? It seems very weird. Committee doesn't make recommendations to itself and then agrees to go in a different direction. Oh, sorry.
I think both of them came from the committee. One is like an extrapolation of the other. So there's a general recommendation.
Maybe a proposal. The committee proposed some things and then they agreed and.
All right. And in F, can we kind of reword F so that it's less, I don't want to ascribe anything to it, but can we just reword F? I think the idea was that there should be a consequential amendment to paragraph 4 to link it to the completion of a term or a shorter period, something like that. Paragraph 2.6. Your committee supported the proposal of MSET that another ground of termination, that is termination for cause, be included in the references to appointment and tenure of office of the commissioner in paragraph 2.6. Additionally, we recommended that there be an inclusion of a provision relating to the procedure to be applied for the termination for cause. New provision to the first schedule, or in the first schedule. Members of your committee recommended that a new provision be included for general qualifications and expertise for appointment as commissioner. That should be your committee. Second schedule, your committee recommended no amendment. Third schedule, your committee raised concern about paragraph 5 of this schedule, which allowed for item C's to be retained as long as necessary, and persons being provided with a copy of any document seized and a receipt of any other item seized. Having considered Section 78 of the Proceeds of Crime Act during our deliberations, we agreed that a provision be included in this schedule to allow for the return of items seized, not seized. Fourth schedule, your committee recommends no amendment. Fifth schedule, we noted that the chairperson of the tribunal is required to be a retired judge of the Supreme Court or the Court of Appeal, and expressed concern that the skill set of other members of the tribunal were not stated. Having advised by MSET of the skill sets of members on appeals tribunals in Barbados, Malta, and the UK data protection legislation, we recommended, end is in sight, that members of the tribunal should possess knowledge in data protection and privacy, and in the minister's opinion represent the interests of data subjects and data controllers. But is that right? Do you want the appeal tribunal to have people who have a vested interest in one side of the... I don't know. It just seemed odd to me that I thought you'd want persons who are independent of bias, you know, yeah. Yes. Yeah. I don't know how you have possessed knowledge in privacy. It seems that, how do you possess knowledge in privacy? We all aspire to privacy. In data protection and privacy law, maybe? Okay, privacy law. Other recommendations. Your committee recommended that since there was a proliferation of appeal bodies established under legislation for a range of matters, there should be amalgamation of appeal bodies to handle appeals across different statutes. Members of your committee, having agreed that provision of the bill will be applicable to data controllers overseas, expressed concern about the enforcement of a judgment against an individual or entity that was not domiciled in Jamaica. Yeah, I don't know if domicile is really the word there, but was not present in Jamaica. Having considered the issue, one member of your committee recommended that the Ministry of Foreign Affairs and Foreign Trade pursue the possibility of Jamaica having reciprocal enforcement of judgment arrangements with key jurisdictions where the data of Jamaicans were processed or being processed.
Sorry. If we can just go back to the first paragraph, I think it should be a little more specific, because as I recall the conversation, it was appeal bodies in relation, it was really ATI appeal. It wasn't just any appeal tribunal and proliferation of just all. Because the discussion was about the ATI appeal tribunal also handling matters under this act, appeals under this act. This just makes it seem as if there's a there are all these appeal bodies dealing with all sorts of subjects, but it actually was a more focused discussion as I recall it.
I think there was both. I think there was a comment about maybe having a appeal tribunal system that was really beyond the scope of this bill, but was an idea of trying to have some efficiency around how appeals are dealt with across multiple statutes. And then there was a more specific thing which was suggesting that for different statutes that are in this general area, you could consolidate and have a single appeal body, as we were suggesting, yeah.
Thank you for the clarification. You have a good memory. So I'm proposing, though, that since we want the committee to work within its remit, that we just clarify that first paragraph. Just do some tweaking.
Yeah, so I mean there should be an amalgamation of appeal bodies to handle appeals across different statutes dealing with similar subject matter. Yeah, something like that? Yeah. Or related subject matter. I was just reading the last part of this sentence in that first paragraph. There should be an amalgamation of appeal bodies to handle appeals across different statutes, and I just suggested the words dealing with related subject matter be added there. I'm not going to read the last bit there of the acknowledgements or the attendance record. Save you all the embarrassment and myself.
All right, I want to thank Member Golden for reading so well. All right, wonderful. So that brings us to the end of the examination of the committee's draft report. Yes, clap yourselves. Thank you. All right, the next step in the process. Do we have to put it to accept the report?
Yes.
All right, I put it to the committee to accept the report with all of the amendments. So moved. So the next step in the process would be to go through the amendments in the bill. Yes. Huh? No, not today. Not today. But I'm just saying that's the next step. The next meeting will be scheduled for the 6th of February at 2 o'clock. Thursday, the 6th of February. On the 6th? On Thursday?
February.
Because she's the leader of opposition, so she would know. Just ready for the 13th.
I want to still set it.
No, but she already said. She would know because she's having discussion with the leader.
Okay. All right. Yeah. Okay. That sounds very good to me.
What we could do, Madam Chair, is we could say to members, we have the tracked changes to the bill. If anybody wants to submit any comments on that, they have the rest of the week to do so. we could ask for the revised report to be circulated to the members by email, give them that week to comment on it, and if there are no comments, one assumes it's okay, and we treat it as a final report to be signed, by circulated for signature. And we don't actually have to come back. Yeah.
Love that idea. All right. So that's what we will do. All right.
So when members supposed to
Sorry, once you send it to me, I'll let you know. All right. All right, so we've agreed that the amendments to the report would be made. Would there be any amendments to the bill made as well?
We've been going through it, Chair, and there are now some square brackets and there are some blank spaces. I think, for example, in one of the definition section. So there are things that certainly the technical team at the ministry would be recommending. So we would want to share those recommendations with the committee. We would one last meeting to just go through that, because there are some square brackets and we don't think.
So next legislative year then, or you think we can do it?
So that would be the 6th.
Of?
No, sorry, the 13th. Yeah. So, but we're not
the
linked.
Budget? You're going to meet during the budget period? But we don't normally, I don't think Parliament normally sits during the budget process. But, I think committees can sit any time still. Yeah. So if you want to do it during, some of us may be focused on.
Okay. Right. So let me look at for the finance committee. Okay, so we're going to set it for February 13th in light of the fact that on the 6th, the Senate might go into the afternoon, right? On the 6th, you're saying the Senate may go over? Yeah. No, that's not the date. No, not date. But they'll be meeting on the 12th though. But PAAC meets on Wednesdays. No, but once it's laid on the 11th, right? It goes to the Auditor General, doesn't it? Right, but it would not come back within that week. It wouldn't come back within that week. Yeah. Right. So it wouldn't come back, yeah. Yeah. Or so the 13th. And in between now and then, we will email out to you the revised report and the revised bill, if there are any cleaning up things to be done there. And Ms. Murray, you're saying you would come with whatever needed to be changed in the square brackets and all right. So I'm asking members to read the revised bill and the report so that when we get here, we can simply accept the bill, or if you have any issues, questions, concern. All right. So I'm going to assume that you will read this because we're not going to go through it clause by clause again. Okay? So, February 13th at 2 p.m. No, because there's a Bank of Jamaica committee joint select committee meeting on that same day. On the 13th. See there? BOJ at 10 a.m. Are you on that committee? To what? Okay. So we could.
No.
What?
They had set some dates, so we can't touch their dates unless.
Okay. All right. All right. Well, the date and time that we have right now is February 13th at 2 p.m. Because on this schedule, Bank of Jamaica is listed as. All right, so you can. All right. Any other business? Meeting of the Joint Select Committee to consider and report on the bill shortly entitled the Data Protection Act 2017 is hereby adjourned. What?
It's a BOJ Act. It's Tuesday, February the 4th. So the BOJ Act on is Tuesday, February the 4th. So If I am to attend on the 13th, it needs to be in the morning. Otherwise, I won't be able to come. So, you know, obviously, if it's inconvenient for others, then so be it. But if it's not, and if you don't have any particular preference, it would be easier for me. I would be able to come at 10 in the morning, but not
All
in the
right, I'll ask Cheshan to find out.
Okay.
Because it's written on her schedule and she can't change it right here, right now.
What is written on her schedule?
Bank of Jamaica.
No, it's the 4th of February.
No, but I'm just saying she can't.
Oh, unless
She has it on her schedule and she won't be able to change it right here, right now. So she's going to make inquiry, and if it isn't, then we will schedule it for the morning. All right. Thank you so much. Thank you. Yeah.
What can a little germs do?
Pink eye running belly, even flu. Germs can make them happen to you.
Put germs on our manners with these. Cover your mouth when you cough and sneeze. Always wash your hand with water and soap. Keep dirty hands from your eyes and your nose and your mouth. You don't want to be sick, take care. Practice every day, no germs around here. A message from the Ministry of Health.
Brutality isn't a legality. There's no rationality as to why this abnormality should become a mentality. A mentality which